Right now, the app you use to watch funny dog videos or message your friends is, well, it's undergoing this radical legal rebrand.
Oh, completely.
Yeah, courts just aren't looking at it as a communication tool anymore. They're classifying it the exact same way they classify a defective airbag or like a toxic toy.
Right, as a negligently designed product.
Exactly.
It forces a complete mental shift.
Yeah.
I mean, you have to stop seeing your screen as this neutral window to the outside world, and you start seeing the gears, the levers, and, the psychological tripwires intentionally engineered right behind the glass.
Which is wild. And that structural reality is what we are unpacking in today's deep dive. We are looking at a seismic shift in the digital world.
It really is an earthquake.
It is. And our guide for this journey is this incredibly comprehensive March 2026 article from the Global Review. It's written by Dr. Fareed Novin.
A fantastic piece of research, by the way.
So good. Our mission today is to understand how two massive jury verdicts, delivered within just 24 hours of each other, mind you, have basically shattered the legal shield that protected social media giants for decades. We are going to explore what this means for the digital architecture you interact with every single day.
Yeah, because we are watching the legal and regulatory framework of the internet being rewritten in real time.
Yeah.
It is a fundamental rewiring of how tech companies are even allowed to operate.
Before we jump in, just a quick note for you listening. Over the course of this deep dive, we are going to be discussing various government actions, regulations, multi-state lawsuits, all that heavy stuff.
Right.
But our goal here is simply to impartially report the facts and the insights laid out in Dr. Novin's research. We're not taking any political sides. We're not endorsing the viewpoints of the original source material. We're just here to help you understand the massive ideas contained within it.
Exactly. We were looking strictly at the mechanics of this shift,
Yep.
right? And the legal arguments being made, not advocating for a specific policy outcome.
So, to understand this breach in the 30-year force field that protected the internet, we kind of have to look at the unprecedented back-to-back blows that just landed.
The 1-2 punch.
The 1-2 punch of March 2026. Two distinct juries in two different states reaching conclusions that tech lawyers previously thought were literally impossible.
Yeah, they were stunned.
So let's start with Tuesday, March 24th. The case is New Mexico v. Meta. A jury in Santa Fe ordered Meta to pay $375 million in civil penalties.
Which is a massive number.
Massive. And the grounds for this were that the company violated consumer protection laws by misleading users about safety and, crucially, for enabling child sexual exploitation.
The evidence presented in that trial was frankly staggering. I mean, the New Mexico Attorney General's office didn't just, file paperwork. They conducted a proactive undercover investigation.
Right, the sting operation.
Yeah. Investigators created fictitious social media accounts posing as children under the age of 14, and the results were immediate. Those fake accounts began receiving unsolicited sexual explicit material and were actively contacted by adults seeking similar content. The operation generated multiple criminal referrals.
And the internal communications that surfaced during the trial really highlighted the corporate decision-making process behind closed doors. The prosecution focused heavily on a 2019 decision by Meta CEO Mark Zuckerberg.
Oh, the encryption decision.
Yes, to implement end-to-end encryption on Facebook Messenger by default. And I really want to pause here because the mechanism of why that matters is so critical.
It's the whole ballgame.
Before end-to-end encryption, platforms could use automated software to scan messages for known hashes, which are essentially digital fingerprints of illegal child sexual abuse material.
Right. But when a platform implements end-to-end encryption, they intentionally blind themselves.
Right.
Only the sender and the receiver have the keys to unlock the message. And the internal memos presented in court show that the company fully understood this architectural shift would impede the reporting of millions of instances of abuse to law enforcement. They weighed privacy against safety, made a deliberate choice, and the jury decided the choice carried massive financial liability, imposing the maximum statutory penalty of $5,000 per violation is what brought that total to $375 million. It was the first time a U.S. state prevailed at trial against a major tech company over child safety claims.
Then you wake up the next day, Wednesday, March 25th, and a jury in Los Angeles delivers a verdict in KGM v. Meta and YouTube.
Second blow.
This resulted in a $6 million combined verdict against both platforms. The charge here was negligent design causing harm, and this centered on a young woman identified in court as Kaylee.
Kaylee's testimony was It provided the human element to all these abstract tech concepts. She detailed how she started using YouTube at age 6. 6 years old, and Instagram by age 9. By the time she was a teenager, she was spending up to 16 hours a day on these platforms.
16 hours, that's practically every waking minute.
Exactly. And she described the emotional rush she felt from the notifications and the likes, which eventually spiraled into severe mental health issues, including body dysmorphia, depression, and suicidal ideation.
Okay, let's unpack this, because suing over what people post is one thing. But this feels like suing the city because a pothole ruined your car, except here, the pothole is the app itself. It's like suing a casino. You aren't suing them because you lost money playing poker. You're suing them because they pumped in extra oxygen, removed all the clocks, and deliberately designed the environment so you wouldn't be able to leave.
That casino framework is highly accurate for what the plaintiffs argued. I mean, for decades, if you tried to sue a tech company because someone bullied you on their platform or because you saw something harmful, the companies would just point to the law and say, "We didn't write the post, we are just the bulletin board."
Right. Don't shoot the messenger.
Exactly. You can't sue the bulletin board for what someone else pinned to it.
And that was their impenetrable armor. Which brings up the million-dollar question. How did these lawyers breach it? How did they pull off this legal magic trick in March 2026 when thousands of lawyers fail before them?
Well, the armor is Section 230 of the Communications Decency Act of 1996. It is the statutory foundation of the modern internet. It literally says platforms are not responsible for third-party content.
Right, the 1996 law.
So to bypass it, the lawyers executed this brilliant pivot. They introduced a new legal architecture, the conduct versus content distinction.
Conduct versus content.
Right. They essentially said, we aren't suing you over the videos or the posts.
Right.
We don't care about the content. We are suing you over your product design, your conduct.
Oh, that's clever. And Dr. Novin's article lists the specific design features they targeted, and honestly, it reads like a psychological playbook. They pointed to the infinite scroll, algorithmic autoplay, and notification systems calibrated to trigger anxiety-driven return visits.
What's fascinating here is that this distinction forces us to view algorithms not as neutral tech, but as deliberate corporate conduct that carries consumer safety obligations. Let's look at variable reward mechanics for a second.
Okay.
It is the exact same psychological principle as a slot machine, known as a Skinner box. When you pull down to refresh your feed, you don't know if you're going to get a text from a crush, a like on your photo, or absolutely nothing.
Right, that little spinning wheel.
Yeah. Neuroscience shows us that the unpredictability of the reward spikes your dopamine far more than a guaranteed reward. The platforms engineered that unpredictability directly into the interface.
But wait, isn't a recommendation algorithm inherently tied to the content it serves? How do you separate the car from the road? If I scroll infinitely, I'm just looking at more content. So shouldn't that still be protected speech under Section 230?
See, that was Meta and Google's primary defense. They argued you cannot disentangle the algorithmic delivery system from the speech it delivers. It's all one thing.
It makes sense on the surface.
It does. But judges in these pretrial rulings, like Judge Carolyn Kuhl in Los Angeles, fundamentally disagreed. They ruled that while Section 230 protects the publication of the content, it does not protect the timing of the engagement loops. It doesn't protect the lack of parental controls.
Oh, wow.
You can evaluate the safety of the delivery mechanism without ever judging the speech itself. A notification buzzing your phone at 2:00 a.m. isn't free speech. It is a manufactured product feature.
That is a massive distinction. But to successfully argue that the design itself was negligent, the plaintiffs had to prove that the platforms knew exactly what they were building, right? They had to prove intent, or at least awareness. We're not talking about accidental side effects here.
Oh, no, not at all. And the internal communications entered into evidence were devastating to the platform's defense that they were merely passive hosts. They knew exactly who they were targeting and how effective their tools were.
There was one explosive internal meta memo presented in court that just stops you in your tracks. It read, "If we want to win big with teens, we must bring them in as tweens." Yeah. They also had data showing that 11-year-olds were 4 times more likely to return to Instagram than to competing platforms, even though the app legally requires you to be 13 to even create an account.
Right, and you contrast those private internal strategies with the public testimonies of the platform executives, and the cognitive dissonance is just glaring. You had Instagram head Adam Mosseri testifying that social media is problematic but not clinically addictive.
Unbelievable.
And you had YouTube's vice president of engineering testifying that his own kids use the platform for several hours a day, and he considers it good for them. insisting the platform wasn't designed to maximize watch time.
This massive gap between the internal research and the public denial is exactly why public discourse has latched onto the big tobacco analogy. Dr. Novin notes that everyone from attorneys general to legal scholars is comparing these tech platforms to the cigarette companies of the 1990s.
It's everywhere.
Because both industries generated unprecedented profits, had internal research documenting harm to youth, actively targeted those young users to secure lifetime customers, and relied heavily on legal immunities until a tidal wave of litigation finally broke through.
Structurally, the parallels are undeniably strong. But Dr. Novin is careful to point out the limits of that analogy. Tobacco is a physically addictive product whose primary, singular function is the delivery of nicotine. The harm is universal and physiological. Social media, on the other hand, is functionally complex.
Right. A 16-year-old might face severe body dysmorphia and suicidal ideation from Instagram, while a 40-year-old uses that exact same platform to successfully sell handmade goods to support their family. You can't build a business selling knitted scarves on a carton of Marlboros.
Exactly. The remedies have to be completely different. With tobacco, the ultimate public health solution is simple. You quit smoking. But social media is integrated into our educational, occupational, and civic infrastructure. You cannot easily ask a citizen to quit the civic infrastructure of the modern world.
Which means the goal here isn't prohibition like tobacco, but design modification.
Right.
We aren't trying to ban the internet. We are trying to force the modification of its most toxic, engagement-maximizing features. And while these massive legal vulnerabilities are playing out in the U.S. court system, the rest of the world has decided they are absolutely not waiting for judges to act. We are seeing a global domino effect.
The legislative wave is moving at an astonishing speed. In December 2025, Australia implemented a historic law banning social media outright for kids under the age of 16.
Outright.
Yes. The platforms were legally obligated to enforce it at the network level. In just the first month of operation, 4.7 million accounts belonging to teenagers were suspended in Australia alone.
Just turned off overnight. And it's not just Australia. France passed a ban for kids under 15. Denmark is drafting similar rules. Even within the U.S., states are taking action since the federal government has been slow to move. Rather than just passing sweeping bans, states are targeting the design itself.
Which is the real threat to the business model.
Exactly. If you are a teenager in California right now, your digital experience is completely different than it was a year ago. State law, SB 976, mandates you can't be served an addictive algorithmic feed. You just see chronological posts from people you follow. In Minnesota, before you can even access the service, you are hit with mandatory mental health warning pop-ups.
If we connect this to the bigger picture, this global regulatory convergence clashes violently with the underlying business model of the internet, the attention economy.
Let's break down the mechanics of that attention economy. If courts and lawmakers mandate the removal of the infinite scroll and they turn off the algorithmic autoplay, the natural result is that users spend less time on the apps. You check your chronological feed, you reach the end, and you close the app. Less time on the app means less advertising inventory.
Time is literally money in this ecosystem. Advertisers pay per impression. If the average user's session length drops from, say, 60 minutes down to 15 minutes because the addictive hooks are gone, the platform's ad inventory shrinks by 75%.
That is a massive hit.
It is. If they're forced to prioritize design safety over commercial optimization, it doesn't just hurt the tech giant's stock prices. It affects content creators, digital marketing agencies, and all those small businesses that migrated their ad budgets away from television to rely entirely on hyper-targeted social media ads.
Here's where it gets really interesting. The litigation we talked about in this new legislation are feeding each other in a massive feedback loop. The internal documents unearthed in discovery and the jury verdicts from the court cases provide the documented evidence that lawmakers need to justify these strict new laws to the public.
And the cycle continues. Once those new safety laws are on the books, any platform that fails to perfectly comply with them creates immediate statutory grounds for even more negligence lawsuits.
But the tech industry isn't just going to surrender, right? They have billions of dollars, and they are facing an existential threat. Dr. Novin mentions there are 1,600 state plaintiffs in California alone, plus over 2,400 federal cases consolidated in multi-district litigation.
Right, which is basically when federal courts pool thousands of similar cases together so the legal system doesn't completely clog up.
Yeah. So with that kind of scale, they have to mount a final defense on appeal. If I'm Meta's lawyers, I'm looking at Kaylee's case and thinking, how can you possibly prove our app caused her depression when she's also dealing with high school bullies, a pandemic, and family stress?
You've hit on their exact legal strategy. Their ultimate defense comes down to the complex science of human minds. Meta argues that causation in mental health is multivariate. A user's distress is rarely caused by one single input.
Plus, scientists can't ethically run randomized controlled trials where they lock one group of kids in a room with an iPhone for 5 years and deprive another group just to see who develops suicidal ideation. So the science relies heavily on observational studies, which leaves the direct causal link highly debated in peer-reviewed literature.
And the tech companies lean heavily on that scientific bottleneck.
Yeah.
They argue that without perfect, undeniable causal proof, you cannot hold a product liable for a complex psychological outcome. But the juries, in March 2026, bypassed this entirely using a different legal threshold called the substantial factor standard.
Wait, so the law is basically saying we don't need a perfectly controlled lab experiment. If a house is on fire, we don't need to prove the match was the only heat source or that the dry wood didn't contribute. We just have to prove the match helped start the blaze.
Yes,
That completely bypasses the tech company's main defense.
that is exactly how the legal standard functions. The plaintiffs didn't have to prove that YouTube or Instagram was the only cause of Kaylee's depression. They just had to prove that the negligent design of the platform was a material contributing factor, a substantial factor.
So what does this all mean? If the science isn't 100% settled in the academic journals, are these massive history-making verdicts ultimately just built on sand, vulnerable to being overturned on appeal?
This raises an important question about how society governs risk. What Dr. Novin points out is that this regulatory posture is revolutionary because governments and juries are no longer waiting for absolute scientific certainty. They are acting on the basis of plausible risk.
Plausible risk.
Exactly. It is incredibly similar to the early days of seatbelt mandates. Lawmakers didn't wait to understand the precise kinetic physics of every single varied car crash before deciding that maybe tying people to the chassis of the car was a good idea.
Right, they just acted.
They saw a plausible risk of harm and mandated a design change for safety. The courts are applying that same logic to the architecture of the internet.
We are witnessing a monumental transition. We are shifting from an era of uncontested digital immunity, where tech platforms could do no wrong under the shield of Section 230, to an era of intense design accountability. As Dr. Nevin summarizes, the question facing courts and regulators is no longer if tech companies have safety obligations to their users, but what those specific obligations actually are.
The era of move fast and break things has violently collided with the reality of product liability law. The legal system is finally demanding that these companies sweep up the broken glass.
For you listening, this isn't just some abstract legal theory happening in a courtroom far away. This is about the underlying machinery of the very apps sitting in your pocket right now. Over the next few years, the way you interact with the digital world is going to fundamentally change as these engagement features are stripped away or heavily regulated.
Absolutely.
Your feeds will look different, your notifications will behave differently, and the economic engine powering your favorite creators will have to adapt.
The interface of the internet will become less demanding of your constant attention. It is a forced evolution of the digital landscape.
Which leaves us with a fascinating, lingering thought. If platforms are eventually legally forced to design for health and safety rather than engagement, who exactly gets to define what a healthy digital interaction looks like? Is it a judge, a tech CEO, a government committee? And when the internet is finally stripped of all its addictive hooks, the variable rewards, and the endless scrolls, will we actually still enjoy using it, or will we realize we only ever loved the slot machine?